Hi, this is Terica Talbert with Century 21 Blackwell and Company. This is where we're going to share information on general real estate, financing, home improvements, and also empower you with inspirational information that will help you throughout your week. Stay tuned. I think it's going to be a blessing to you. Welcome, I'm Terica Talbert, and thank you for tuning into my YouTube channel, Tuesdays with Terica. This morning, I'm talking with Natalie Bialas with Guest Brady Law Firm here in Greenville. Hi, Natalie.
Hello,
thank you
Terica.
so much for taking time out to come out and just chat with me.
I'm excited. Thank you.
I am too. Most of you may not understand, but attorneys are very difficult to get because they have a whole lot going on. They've got a lot on their plates. They're taking care of us legally. So I really, really just want to thank you so much for just taking out a few minutes just to share with me
My pleasure.
and our audience.
Anything for Terica.
So it's been a few years now, but I had a closing scheduled with Guest Brady. I used the one that is here in Greenville, right off of Hampton. We'll give you all that information a little later. And I had a situation with one of my closings, and Natalie was so gracious in how she finagled everything to make it all come together so that my seller was comfortable and we didn't have to do some interactions, which was really a good thing. So it was just so comfortable. The office was so great as we were going around because it was my first time there. They didn't know me from Adam's aunt, but nevertheless, they took such good care of me and my client, of course. But we were walking around and they showed me their prayer room. Oh my gosh, can you believe that? So Natalie, if you don't mind, can you tell the audience, how did that come to be? Because that's not normal.
Yeah, we think of it as our Father's office. We're a faith-based law firm. We handle personal injury, workers' comp, real estate. I'm on the real estate side. But everything that we do is for Him. So we like to have a special little prayer room, which, let's be honest, sometimes in transactions you need a little extra prayer.
Absolutely.
It's a place you can go in, say a prayer, have a moment of solitude. We have stones where you can write a little message on a stone. We have that open to the public. So if you are driving by our office having a really difficult time and just need a place to go in, have a moment of solitude and say a little prayer, that is your spot.
I think that is so wonderful. And as my viewers hopefully can attest to now, what I am trying to do with this channel is to give encouragement and life and inspiration to help people throughout their week. And so when I thought about being able to have a conversation with you, I said, I have to make sure that everyone knows if you've got a situation going on, and you're in the Hampton area, you are more than welcome to go for legal information, of course, but if you need somebody to just touch and agree with you in prayer, they are available. And I thought that was so wonderful because they're not so busy that they forget what we're here for, and that is to serve. So I thought that was office. That's just so awesome, just so awesome. Okay, so we're gonna get down to some real business. Okay, so as a real estate attorney, how long have you been in the business?
Gosh, over a decade, about 13 years now.
13 years, and in the 13 years, you can attest to everyone that the market has changed.
It has changed.
Are you guys as busier? What is your flow?
We are very, very blessed in that we have really stayed busy. We've maintained busyness throughout the ups and downs of the market. Sometimes you're busier with refinances and equity lines and construction loans, sometimes with purchases. So right now we're heavy on purchases right now.
Wonderful, wonderful. Okay, so when we are, as realtors, we are assigning our clients to come to you for the closing.
Right.
And what does that actually entail on your part? I know that you're not the one that's doing all of the work, so you have paralegals and you have different ones that do different things. Do you mind sharing a little bit of that with our audience?
Absolutely. It takes a team.
It takes a team.
It really does, not just the realtors and lenders involved, but just within our office alone, we have multiple people with multiple roles. So as soon as we get a contract, we have someone that opens the file. We order what's called a title search, which is a snapshot of the property between 40 and 60 years, depending on the type of transaction. We have someone who will actually go out, prepare the title search. That's called a title abstractor. They prepare the title search. I'll review the title search. We have someone that prepares what is called a title commitment, title documents that we send to the lender, which is really just taking all the information in that title search, creating what's called the title commitment, and it's like a little packet of information, things that have to be addressed prior to closing. It gives a legal description of the property, so that the lender will know exactly what's being conveyed. So we have someone that prepares that. We have paralegals that are just phenomenal. I can't sing their praises enough.
Phenomenal.
They do so much. I mean, I feel like, where do I even start with the paralegals? But their primary focus is getting all of the information compiled for the closing, and with the attorney overseeing. And we're so busy right now, the paralegals even have assistants.
Absolutely.
So they're assisting the paralegal and the attorney in the process. And we're compiling the information, invoices that may need to be paid for the closing.
Which would be invoices of repairs. That's something of the past. But any other invoice of anybody that needs to be paid that has been a part of the transaction.
Right. Even things like inspections, making sure inspectors are paid. Putting all of that information on what's called a settlement statement. And that is just a list of fees. So it's showing all of the money coming in for the closing and all the money going out for the closing. And
so let me just kind of interject here for just 1 second. So when you guys are calling or contacting us about how much do you have to bring to closing, or how much are you going to net from the sale of your home, we can give you an estimate because we're just realtors. We are not anything legal as far as your lender or the attorney, but the attorney goes over those numbers that the lender gives them. So whatever the lender projects, the attorney goes over it with a fine-tooth comb just to make sure that the numbers line up, and then they're able to confirm what you're supposed to bring. So you will hear that information from your lender first, and then from the attorney. The attorney only confirms it.
And one thing, Terica, that I think a lot of people forget, in South Carolina, attorneys, unless sellers choose a different attorney, by default, attorneys will represent both buyer and seller in the transaction.
Yes.
So that's something that I think a lot of times people tend to forget.
And one thing that I have experienced in my career as a realtor is that some people will say, well, I want to use my own.
Right.
And I'll say, okay, you have that right, you have that choice. But the reality is, it's across the board what you're doing, and that is to verify information.
That's right.
So yes, you can have your own individual attorney. You're probably going to pay a little bit more because you do get a slight discount for being able to have everything all in-house with the one attorney. And again, it's just that they are confirming information. They're doing the same job that any other attorney would do. They don't play favoritism for a buyer or a seller. It is what it is. So
yeah, and the biggest role that attorneys have are really in two parts. One is making sure there's clear title. We are not going to convey property unless there is clear title. And then the other part is making sure that everyone's getting paid that's supposed to get paid.
Absolutely.
And that they're getting paid what they're supposed to get paid.
So can we revisit clear title?
Yes, that's
okay.
important.
So what that means is, and you can correct me if I'm wrong, if someone has their name on the title, they're the ones that have the authority to sell it. Correct?
That's correct.
Okay. However, if there is a party that has not been named, a spouse passed away, their portion of the property goes to their children. Their children passed on, and it passes down to their children. Somebody may still have interest in that property, and it's the attorney's responsibility or job through the title search to make sure that there isn't somebody that has not been actually listed as the first person that doesn't have any interest in the property. Can you kind of explain that a little more
Really,
clearly?
I guess two parts. One is, clear title can also be that there are old judgments and liens and mortgages that never got addressed.
Yes.
Or new judgments and liens and mortgages that need to get addressed. So it could be something as simple as that. There are all kinds of ways that you can have what's called a cloud on title. We can talk more about that in a minute, but I guess kind of digress back to, if someone passes away. That happens a lot where, it's, say, two spouses that own property. Now, in South Carolina, you can own the property as joint tenants with right of survivorship.
Okay.
That means that if one spouse passes away, then the deceased spouse's interest just transfers 100% to the surviving spouse.
Okay.
If that's the case, then we're great. We can close, not a problem. The problem will arise when they hold title as tenants in common. So that means that the spouse who has passed away, that person's interest doesn't automatically transfer to the spouse. Now, if there's a will, that certainly helps. If there is no will, that can create an issue like you're talking about, because, say that person that passed away was married to the other person on title, and say has 3 children. Well, if they do not have a will, then there's something in South Carolina called the laws of intestacy. So that's what we have to follow to determine who actually has an ownership in this property. So in our little scenario, the surviving spouse has, we'll say the husband passed away.
Okay.
The surviving wife has her 50% interest. That is how it was on the deed. Then the husband who passed away, his property or his interest in the property is divided 50% to the wife. So she now has her 50% plus half of his 50%. So we're having to do some math here. And then the 3 children will split the other 50% of his interest 3 ways. So you have to do the math. So I mean, you have to.
It can get complicated.
And then you have to think too. Have any of those children passed away? That can create issues. So there are all kinds of things that we have to think about.
And the reason why I brought that up is because, in my experience, I had a client that had a property that she thought she and her mom owned, and she did not own it because there was no will. There was no will. And so with that, she had to share with 15 other siblings what she thought was her home that she had been paying for years. So my conversation with you as viewers, make sure you have your business in order. Whether it's grandma's property, grandpa's property, an older person, understand what's going on so that when you come to me to list the property, we already have an idea as to what's going on. And that makes it a little easier for Natalie, our closing attorney, to at least know what they may be faced with. So that's a big thing.
And I can't encourage people enough. If you're a married couple and you think you have joint tenants with right of survivorship on your deed, still double check.
Double check.
I had a phone
That's
call
right.
actually from a lady yesterday. She was certain that that's how her deed was structured because she had told her closing attorney that's how she wanted to hold title. Well, lo and behold, her husband has just passed away. She wanted me to just double check the deed because she's wanting to sell the property. And lo and behold, that is not how she held title. So she is devastated that now she's having to track down her 3 kids who are all over the world to try to get them to sign
make it
off,
work,
to give her the interest that she thought she always had all along.
Wow, that's something.
So check your title, check your deed, how you hold title, and like Terica said, get a will.
Get a will.
Because it's a sad thing, but I've had closings where it's someone very young who has passed away, very unexpectedly. And, you know, the surviving spouse in his 20s was selling property, and his wife had just passed away in a car accident. So these things happen to young and old.
Absolutely. So while we're on this, is this the title, what we're talking about, the title search and so forth, how does that play for estate property, people that have received property through an estate?
Yeah, so first thing to kind of backtrack a little bit is our title search is going to show if there are any estates affecting the property. Okay. So that's very helpful. So sometimes, you know, I'll have people call and say, you know, can you tell me where we are in the process with probate? Are we ready to sell? You know, if there is no will, that can create an issue. So, you know, we'd have to have probate court's authorization to be able to sell the property. Some wills, too, will not give the personal, can't talk now, sorry, personal representative,
it's okay, it's okay,
the power to sell property. So, you know, that's another thing. You want to have an attorney in South Carolina, if you're living in South Carolina, prepare the will.
Right.
Because, you know, if you just go out and get a template offline, it may not be specific to your state.
Yes.
So when we get, you know, we may think everything's good, but then when we get the, you know, the title search back, we're looking at that will, and the PR has no authority to sell the property. So to be able to move forward in your closing, you would have to have a probate judge sign off an order saying you're now authorized to sell the property. So that's a really big deal, and that all will be revealed in our title search.
Right. Okay.
So backtracking a little bit more, I'm trying to remember what your initial question was, Terica. You're asking about estates and selling property.
Yeah, just estate sales. Sales. So how does that play into what you guys do?
So the PR would be the one who is the actual seller for the estate. And that's something that can sometimes upset heirs, because if the PR is selling the property on behalf of the estate, the closing proceeds will go back to that estate. So the estate should have an account with some bank somewhere.
Right.
So that check is written out to the PR of the estate. That person will deposit those proceeds, and then that person who has been appointed, you know, by the probate court can, you know, divide whatever money need to go to whichever heirs. But sometimes we'll have heirs call us saying, well, why can't I get the money from the closing? They don't realize it has to filter through the estate. Now, in South Carolina, again, all of this is South Carolina law that we're talking about.
Well, that's all we're concerned with.
Now, depending on where you are in the estate, in the probate process, when your seller is an actual estate, if you're closer to the end of the probate process, which can sometimes take up to a year, then sometimes we can go ahead and have what's called a deed of distribution, where the PR is going ahead and before the closing, it's sort of like a deed in a sense, in that it's evidencing who's supposed to hold title to the property, who's supposed to inherit the property.
Right.
So it will go ahead and designate those individuals or individual. And then that person is now our seller. So it's not completely uncommon for a contract to start out where the seller is the estate, but closer to the end of the process when we're reaching closing, then now all of a sudden the heirs are the sellers. And we'd have to have a contract addendum just changing who our sellers are.
Isn't it so much easier just to have a will to just basically write out what you want done? In the case that you are not here, there's no question. You have it already done. You've already had the hard questions answered. You've already talked to your family. Everybody knows, everybody's on the same page, and there is no issue, or there's no confusion, I guess I should say, to that effect. So let's kind of jump around a little bit. We're going to talk about surveys, because surveys are really important. Surveys, for anyone that doesn't know or may not be aware, kind of outlines your property so that you know exactly where your fence is supposed to be, so that there's no question or confusion between you and your neighbors. How do you guys play in all that?
I can't stress the importance of surveys enough, Terica. I tell you, everyone needs to have at least somewhat of a valid survey here, because sometimes you'll have what are called meets and bounds, which are just they're calls. mapping out property. So you'll know exactly where your property lines are, but it doesn't give you that visual snapshot of what your property looks like, the shape, what's on the property. And surveys are so important because they give us that snapshot of what the property really looks like. So everyone understands exactly what's being conveyed. You really want to ideally have what's called an as-built survey. So some surveys will just show the property lines mapped out, and it doesn't show any kind of structures on the property itself.
So would that be the same as the little plat that you get when you're a new construction that the builder usually gives? Is that kind of what you're referring to? Or
it's different than a floor plan. A lot of times people will bring me a floor plan. I'll reach out to the seller and ask, do you have a more recent survey of your property that's maybe just not recorded with the Register of Deeds? Because surveys really should be recorded with the Register of Deeds. But sometimes if we don't have a current one on record, I'll reach out to the seller and just ask if they've recently gotten one. They'll come in and bring me a floor plan. So, well, that's helpful for the buyer, I'm sure, to have as well, but it's a little different. So, it's, and some new construction will give out new surveys. I don't know if they all do, but it's
not all of them.
Often to see it, and it's different than a floor plan. That will not help us. But yeah, in our office, part of our duty, again, in reviewing the title search is looking to see, is there a recent survey of the property?
So what is recent? How far do you guys go back that you feel comfortable with saying this is a good survey?
So I would say for me, and that's open to interpretation for different attorneys. For me, I would say about 10 years, unless I know there have been changes to the property.
Okay.
In fact, I had a closing somewhat recently where the sellers had gotten a new survey, I want to say maybe 2 years ago. But since then, a new fence was constructed on the property, and they installed a pool and a little gazebo area. Knowing all of that, I told the buyers, I said, you aren't required to get a new survey. What we have, we can still use to define what property is being conveyed. But you want to think about encroachments, and that's where something's passing over, say, a property line or a building setback line. And so it's important to have a recent survey, an accurate survey, to see if there are encroachments. And lo and behold, our buyers were smart and got a new survey. But of course, there was that encroachment. So they were really glad they spent, those few $100s to get a survey. Because then, if you get a survey before you close and it reveals any kind of issues, well, at that point, it's on the seller's shoulders to address those.
Yes.
If you don't get a survey and say you go to sell the property down the road at some point, and that buyer gets a survey, and that reveals issues, well, then that's on you to fix. So that's why it's a good idea for buyers to have that conversation. Yeah, do it up front. Order it early because surveyors are super busy. Super crazy busy. Yeah, and that's part of the attorney's role too, is to say, okay, should you get a new survey? And we're looking at the title search to determine, is one really required? Sometimes you have to get a new survey, or is it just recommended, or is it highly recommended in some cases?
Well, another thing that we were wanting to talk about, we had some interest in one of our callers wanted us to talk about HOA. So I know that the HOA is the force that governs what goes on within the community. There are fees involved. And so our interested party wanted to know if those fees are something that you guys collect for. Do you come up with the amounts, or how does that work?
That's a great question. So part of our responsibility as closing attorney is to determine who needs to be paid, how much they need to be paid, and which party is paying them. So that's largely dictated by the contract as far as which party is paying fees. And then what we do is we will reach out to the seller, ask, is there an HOA? Because the seller is usually the person in the best position to know that.
Absolutely.
They'll give us the contact information for the HOA. Our office will reach out to the HOA, and they'll give us just really a statement saying, when dues are payable. Are they up to date? Sometimes sellers, unfortunately, have not paid their HOA dues. That has to be collected. And then, also, are there any kind of late fees, assessments? Right now, it's rampant seeing HOAs using these, property management companies as a third party who will unfortunately charge a lot of extra fees just to give us information.
Yes.
So, it's not uncommon for us to be charged hundreds of dollars just to find out, are the HOA dues paid? When are they
Right.
due? Are there late fees?
So there may be, just to recap, there may be a transfer fee that is involved. There may be back fees that the seller is still responsible to pay from their proceeds, and you need to know what your HOA covers. So those are important things for you guys to remember. Okay, Natalie, before we wrap up, there's a couple other things that I just want to conclude. And one of the items is wire fraud. I have had an experience with that with one of my clients, and it wasn't a pretty situation. So what do you guys do to try to help navigate through that process?
Wire fraud is so rampant right now. So at Guest Brady, we're trying to do everything we can to mitigate any possibilities at all of wire fraud. So if you were needing to wire us money for your closing, we aren't even emailing out wiring instructions anymore. So we ask our clients to call the office or even just stop by, and we can print out our wiring instructions. So you can take it straight to your bank to set up your wire.
Which is great. I think it requires a couple additional steps, but it is so worth it because there isn't anything that you can do. Once that money is gone, it's gone.
It's true, and we just want to protect the client.
We want to protect our clients, yes. Okay, so the last thing that we're going to cover is property tax rate, the 4% and the 6%. Can you explain that to our viewers?
That is huge. So as soon as your deed is recorded, your property taxes are just set at 6% in South Carolina. But if it's your primary residence, you're eligible for a 4% property tax rate. It doesn't sound like a big difference between 4 and 6%, but it will double, almost triple your property taxes. The kicker is you have to apply for it.
You have to apply
have
for
to
it.
apply for it. And I think it's a really simple process. I think of it in my mind as a two-step process. Your first step is with the DMV. You need to get your license and registration updated to this new property address. Second part's also easy. The county will mail you the application, but it looks like junk mail. It's one of those little perforated forms. A lot of counties is pink in color, but it really looks like junk mail. I can't stress that to you enough because I talk about this in closings all the time, every day to buyers, and I physically was putting my hand in my garbage can with my application because it looked like junk mail.
So it's easy to do.
It's so easy to do. And then, of course, with address changes, things can get lost in the mail anyway as well. But the application is very simple. It's just a one-page application. Fill it out. And I like to encourage buyers to actually take that application down to the county office as opposed to doing it online or mailing it in, because every year I get phone calls from people that have closed with me, and even though we talk about it,
we talk about it, we talk about it and talk about it.
They will still just mail it in. And then they'll call me down the road, say, Natalie, I mailed in my application. Why is it still at 6%? And I don't know if it just gets sent to the wrong department or what, but I've never, in all of my years of experience, had someone call me and say, well, I took it down to the county office.
So even though it's going to require you to do a little extra, it's worth you walking it down to the county to have your amount to stay what it is, to have your payment stay the same. However, should you forget, you will be able to get a credit up to 2 years. They will reimburse you the overage that you've had to pay in. So again, Natalie, I can't begin to thank you enough for sharing with me today. It has been such a pleasure. I am so honored. I am so grateful for your friendship. For those of you who are looking for a closing attorney, real estate, and you guys do,
We do personal injury.
So they do a variety of things. But she's my real estate attorney, my go-to at Guest Brady. So would you mind sharing with our viewers your contact information and where you guys are located?
Absolutely. Well, we have multiple locations. We have locations in Travelers Rest, Easley, Greenville, and Spartanburg.
Wow, I know.
I'm located in the Greenville office. It's located at 1560 Wade Hampton Boulevard, right next door to Bob Jones University. So right in the center of Wade Hampton Boulevard. The phone number for the law firm is 864-233-7200. My email address is my first and last name is Natalie, Natalie, Bialas, BIALAS at Guest, GUEST, Brady, BRADY.com.
All right. And I am Terica with Century 21, but I am here to be able to help inspire, encourage, and uplift you for your week. So we are here on this YouTube channel to encourage, inspire, and uplift you so that you have information that is beneficial to you throughout the week. So if you guys don't mind, continue to watch my YouTube channel, Tuesdays with Terica. I would like for you to share, like, and subscribe. Thank you so much. Until next time.